good afternoon, or good evening, wherever you might be. My name is Jeffrey Morowitz. It's my pleasure to welcome you to this two-day virtual colloquium on resolution of financially distressed financial institutions. The colloquium is hosted by the University of British Columbia Center for Business Law with the support of the International Insolvency Institute. The topics that will be discussed during the colloquium are both important and they're especially timely, considering today's uncertain environment. It is a busy agenda. We want to keep on time throughout the colloquium. The opening keynote will certainly capture your attention. The topic is Too Big to Fail, from Lehman Brothers to COVID-19. There was certainly a panic in 2008 when the financial crisis hit. And there's a little bit of a panic right now, or at least a lot of uncertainty surrounding COVID-19, both from a medical impact, but also an economic impact. The keynote will be delivered by a gentleman who requires really no introduction, Donald Bernstein, the chair of the restructuring group at Davis Polk, has seen it all. He's been around for, how should we say, a few decades. He actively participated in the Lehman Brothers situation in 2008. He's a founding member, a director, and a past president of the International Insolvency Institute. And he's certainly been afforded every honor that the insolvency profession can confer on an individual. Don will be speaking for approximately 20 minutes, and I think you want to hear from him as opposed to me. So I'll turn it over to you, Don, and thank you very much for making yourself available to address the group today.
Okay. Well, thank you, Justice Morowitz, for that incredibly generous introduction. I also want to thank the Center for Business Law and the Law School, as well as the International Insolvency Institute, for the honor of helping to launch this very timely colloquium, which is taking place actually on the 12th anniversary of the weekend that Lehman Brothers failed. And we're now struggling, as Justice Morowitz mentioned, with another crisis, the COVID-19 pandemic, which is causing enormous disruption around the world. So this colloquium is extremely timely. Lehman Brothers filed for bankruptcy early on the morning of September 15th, 2008. Within a couple of days, most of its global affiliates, including its US broker-dealer, commenced insolvency proceedings too. And within a few days after that, bankruptcy judge James Peck approved the sale of most of Lehman's business to Barclays. 2 nights before the bankruptcy filing, around 11 p.m. on Saturday, September 13th, which is 12 years ago today, I was in a meeting at the Federal Reserve Bank of New York with representatives of several large US banks. Down the hall, Lehman Brothers was trying to hammer out an out-of-court sale of most of its business to Barclays. And the banks were working on a credit line to finance tens of billions of dollars of distressed commercial real estate assets, mostly collateralized debt obligations or CDOs, that Barclays did not want. Lehman had been facing headwinds for a number of months. However, while Lehman's losses on its real estate portfolio were large, most people thought Lehman was still solvent, at least in the balance sheet sense. But around the beginning of September, Lehman began to suffer a liquidity run. Prime brokerage customers were moving their assets out. The market was pulling back on new transactions and refusing to roll old ones without liquid collateral. Not only that, but other financial firms were starting to suffer similar liquidity outflows. In other words, it was a contagious run. And as firms sold assets to meet their cash needs, asset prices declined further, creating further losses and exacerbating the runs. But that Saturday evening, everyone thought Lehman and Barclays would reach a deal. Unfortunately, there remained a hidden stumbling block. An out-of-court transaction would take time to close, perhaps as much as 30 days. During that period, in order to stem the liquidity run and keep Lehman alive, Barclays would have had to guarantee Lehman's trading. On Sunday morning, the senior executives of a dozen of the world's largest banks met at the Fed. They were prepared to agree to the new financing, and they dispatched the lawyers to finalize the commitment papers. Then, unexpectedly, around the middle of the day, the UK regulators refused to approve the Barclays deal. Apparently, Barclays guaranteeing Lehman's trading until closing would not be acceptable. After that, US Treasury Secretary Hank Paulson advised the banks that the United States government was not in a position to bail out Lehman, making Lehman's bankruptcy inevitable, and events unfolded very quickly after that. On Sunday afternoon, the Fed got Lehman's trading partners together to see if they could take Lehman out of the middle of its own financial contract book. In other words, novate the trades to each other. However, with hundreds of thousands of trades, this proved impossible. Lehman filed for bankruptcy later that night. Bank of America agreed to purchase Merrill Lynch, and a couple of days later, the US government bailed out AIG, around the same time as the bankruptcy court approved the sale to Barclays. Because of Lehman's bankruptcy filing, virtually all of Lehman's financial contract book was terminated under the bankruptcy code's financial safe harbors. A book of trades that was probably in the money on a going concern basis was liquidated, and collateral was dumped on the market, generating tens of billions of dollars of losses. Lehman's liquidity run and the aftermath turned a solvent firm into an insolvent one, and it also created contagion that almost certainly would have resulted in systemic collapse without the bailout of AIG and the passage of TARP and other measures to support the financial system. I've spent much of my time since 2008 representing global financial firms in connection with mandated resolution planning. This experience has been daunting, but also, I would say, encouraging. In the US, the Dodd-Frank Act imposed enhanced prudential regulation, resulting, among other things, in substantially increased capital and liquidity requirements for systemically important firms. In addition, it enacted the Orderly Liquidation Authority, or OLA, which permits regulators to resolve distressed, systemically important financial firms through the creation of a bridge financial company. More on that in a minute. OLA also included a funding mechanism known as the Orderly Liquidation Fund, permitting the FDIC to borrow funds from the US Treasury to facilitate orderly resolution. And finally, it mandated resolution planning, detailed plans to resolve the firm while minimizing systemic disruption. Oddly, however, despite the enactment of OLA, resolution planning is to be done under the bankruptcy code. More on that too. These enhancements to resolution preparedness have been paralleled elsewhere in the world with, for example, the implementation of the Bank Recovery and Resolution Directive in Europe and similar legislation in other countries. But let's consider these developments in the context of the lessons learned from the events of 2008. I'm going to focus on 5 principal lessons. Lesson 1 is that systemically important financial firms tend to fail because of liquidity runs and not necessarily because of balance sheet insolvency. While concerns over losses often precipitate the run, panic usually outstrips reality. The run itself and the abrupt liquidation of the firm when it runs out of cash are typically the cause of insolvency, not the initial losses. So lesson one is that the focus should be of resolution planning should be not liquidation, but rather recapitalization of the firm and the continuation of its business. Liquidation is precisely what creates the insolvency. Lesson two is a corollary of lesson one. For recapitalization and continuation of the firm to be possible, the firm must have sufficient total loss absorbing capacity, or TLAC, or as some call it elsewhere in the world, MREL. In other words, the firm needs to have sufficient capital and, in addition, debt that can be bailed in or converted to equity to create new capital. That's lesson two. Lesson three is another corollary of lesson one. To recapitalize and continue in business, a distressed firm needs to maintain a sufficiently robust liquidity pool to avoid having to dump assets at distressed prices to meet a run. In addition, after the firm is recapitalized, it needs to be able to sustain itself until the run subsides and liquidity stabilizes. This means either having sufficient liquidity on its own balance sheet to meet resolution needs, or having access to lender of last resort funding. That's lesson three. Lesson four, which seems very obvious from the Lehman experience. In order to successfully recapitalize and continue in business, the financial contract book of the distressed firm must be preserved. Some resolution statutes, such as OLA and BRRD, address this, at least in part. The Bankruptcy Code does not, though proposed legislation might change this. A great deal of work has been done on this issue since 2008, which I'll discuss in a moment. Lesson five also seems blindingly obvious. Because systemically important firms are global, home and host country regulators need to coordinate and cooperate rather than working at cross purposes. If they don't, each country engages in self-protective behavior like ring fencing or hoarding resources, recapitalization of the firm will be more challenging. So how has the US done when measured against these lessons? I think it's done pretty well, as I'll describe. It has adopted the recapitalization approach to resolution, which is lesson one. Because the US has a holding company model for its large banks, the firm's external TLAC is at the holding company. This means a recapitalization can be accomplished simply by transferring the firm's operating subsidiaries as going concerns to a new debt-free bridge holding company, leaving the TLAC debt behind. This is the so-called single point of entry resolution strategy, where only the holding company fails. This speedy method of recapitalizing a global banking organization has the advantage of avoiding the need for evaluation of the equity of the recapitalized firm at the time of the bail-in. And it can be accomplished either under OLA or under Section 363 of the Bankruptcy Code. So lesson one, check in the United States. The US has also substantially increased requirements for loss absorbency and liquidity, and under OLA, it has implemented a form of lender of last resort. Consistent with global standards, the largest US banks have capital levels that are more than double what they were in 2008. In addition, if you include bail-inable TLAC debt, total loss absorbency is approximately 5 times what existed at the time of the Lehman bankruptcy. The largest firms also maintain triple the amount of liquid assets as a percentage of their liabilities as they did in 2008, and they have more than double the maturity profile of their short-term funding. So that's a pretty good result on lessons 2 and lessons 3, sufficient loss absorbency and liquidity. The US has also required the adoption of contractual waivers of closeout rights under financial contracts, for example, by mandating that the ISDA protocol or a similar waiver be included in financial contracts with systemically important firms. This is obviously important in light of the Lehman experience and satisfies lesson 4. Finally, US and non-US regulators have substantially improved their coordination through organizations like the Financial Stability Board, crisis management groups for individual firms, and bilateral interactions. So that's lesson 5. So these improvements are wonderful. They continue to be operationalized, and they represent tremendous progress. I would, however, like to focus on one area that remains a stubborn challenge. This is internal TLAC requirements. The recapitalization approach to resolution is effective because the issuance of TLAC instruments creates an internal pool of assets that is sufficient to bridge the firm's capital and liquidity needs until the firm stabilizes. Ideally, the entity issuing the external TLAC, usually the top company in the banking group, reserves these assets and is committed to use them wherever needed to support the firm's global operations, not only in the firm's home country, but around the world. In accordance with their resolution plans, the US global systemically important banks, for example, reserve a substantial pool of assets in an intermediate US holding company. This IHC enters into an agreement with all of the material operating subsidiaries secured by that pool of assets to provide capital and liquidity support to the subsidiaries on an as and when needed basis in times of financial stress. The question that global regulators are currently struggling with is whether the corporate group that has this asset reserve should maintain it near the top of the house or whether it should be allocated among the operating entities. Host countries, of course, are naturally inclined to have this pool pre-positioned locally rather than controlled by the top company in the group or an IHC. This can be done through the creation of so-called internal TLAC, where the resources get loaned downstream to the subsidiaries, so the subsidiaries themselves have their own bail-inable debt. However, in a distressed scenario, losses and liquidity needs are rarely uniformly distributed across the firm. Excessive prepositioning in advance of knowing where the needs will be reduces flexibility and accordingly increases systemic risk, in my view. A distressed firm can be fully resourced for resolution, but if it cannot move assets sufficiently freely because of excessive prepositioning, the success of its recapitalization could be threatened. It is quite understandable that a host country regulator might say, I know the home country has plenty of external TLAC, but how can I be sure those resources will be pushed down to the local subsidiary when it needs them? So we are going to insist that a large amount of these resources be pre-positioned here today. This dearth of trust is totally understandable, but it is leading to a tragedy of the commons. Because if excessive pre-positioning in one entity leads another entity in the group to fail, the whole firm could collapse. That is not to say that there shouldn't be pre-positioning. a down payment on the support commitment. But a balance needs to be struck that both protects the local entities and that allows sufficient flexibility so that recapitalization can work. This is a challenge that I hope you will discuss over the next 2 days. In sum, though, I am encouraged that so much progress has been made in the years since Lehman Brothers failed. In the US and in many other parts of the world, we have a much safer and more resolution-ready banking system. And through colloquia like this one, we can continue to build on the lessons we have learned and make even further progress. In doing this, though, we should be mindful that however resolution-ready our financial firms are, ultimately, their soundness depends on the resiliency of the real economy. Your work here is to prepare for the worst, but we also need to hope that our policymakers will take the steps necessary to make sure that the worst does not occur. I want to end by thanking you again for offering me the opportunity to speak to this colloquium, and hopefully you will make a lot of progress over the next 2 days. Thanks a lot.
And thank you, Don. I note that we have 99 participants. I think I saw all of them writing down the 5 lessons and perhaps the lingering stumbling block, but all of us are going to come away with your address feeling a little bit more confident as we prepare for the uncertainty in the months and perhaps years ahead. But again, thank you very much for an inspiring opening keynote. And I'd like to now turn it over to the panel chair for the first panel, Justice Kathryn Feldman from the Court of Appeal from Ontario. Kathryn, please take it away.
Thank you very much, Chief Justice. Welcome to the first panel, Insights from Asia's Financial Resolution Systems. I'm very pleased to welcome 2 very distinguished panelists. Professor Hideki Kanda is Professor of Corporate Law, Banking, and Securities Regulation at Gakushuin University and Professor Emeritus of the same subjects from the University of Tokyo. He is an expert in Japanese corporate law and Asian corporate governance and restructuring. Mr. Patrick Ang is a leading insolvency and commercial practitioner based in Singapore. He's currently the managing partner of Rajah and Tann Singapore and vice chairman of Rajah and Tann Asia. He represents major Asian financial institutions and corporations, and he is a fellow of the American College of Bankruptcy. I'm going to first call on Mr. Ang to talk about the Asian financial crisis in the 1990s and the resolution processes that followed that. Please go ahead, Mr. Ang.
Thank you very much, Justice Feldman. Good morning, afternoon, and evening to every one of you. Any discussion that you have on Asia's financial institutions in insolvency, restructuring, or resolution systems has to discuss the Asian financial crisis in 1997. And I think if you recall, the financial crisis in Asia started in Thailand. So perhaps we'll move to the next slide. And if you remember, the Asian financial crisis, when it started in Thailand, was described as the Tom Yam Kung, which in Thai is a famous hot and sour soup in Thailand. And it reflects the hot money which was pouring into the region during that period. And I think the sourness came after. The effect of the Asian financial crisis was most deeply felt in particular in Thailand, where it started, Indonesia, as well as South Korea. countries which were least affected, namely China, Japan, Singapore, Vietnam, and Taiwan. Not that these countries were not affected, but they probably suffered the least for various reasons. Moving on quickly to the next slide, I'll briefly touch on the main causes of the Asian financial crisis. If you read academia discussion as well as commercial discussions on the causes, there are many, but I thought I'd just pick four. The first being fixed foreign exchange rates during that period instead of floating rates, which of course made it very attractive to companies to borrow, particularly in US dollars. So there was heavy foreign exchange borrowings during that period. And this was caused mainly by the fact that in the 90s, you will recall the phrase, the Asian economic miracle that came about during that period. You may also recall phrases like the Asian tigers, referring to certain economies in Asia which were growing at very fast rates. Unfortunately, those fast rates created asset overvaluations resulting in a bubble economy, which unfortunately collapsed in 1997, which was when the Asian financial crisis started in July. And finally, the last factor I wanted to highlight was this concept of crony capitalism, which was fairly rife during that period. It still exists in forms, various forms even till today, but it was fairly rife during that period where banks would exercise discretion to lend to borrowers who were not necessarily suitable or fit to borrow or to use the funds. Moving on quickly to the next slide. I do not have time to cover all the various countries in Asia, but I thought I'd highlight two countries for their differing approaches to the Asian financial crisis. So first you have Indonesia. And during that period, I remember I was a new partner in my law firm, and I just started doing insolvency after the collapse of Barings in 1995. So when the Asian financial crisis came in 97, I was in the thick of restructuring in Singapore. And we had quite a lot of cases which basically were Indonesian companies which were undergoing restructuring or insolvency in the Singapore courts. And that was one of my first real deep dives into restructuring and insolvency in my career. You'll see the impact of the Asian financial crisis in Indonesia. 65 banks closed, 9 of them merged. There is a famous bank in Indonesia, which is the largest, called Bank Mandiri. Bank Mandiri, incidentally, in Bahasa Indonesia, means self-reliant. All right, and Bank Mandiri was a merger of 4 banks and created the largest bank in Indonesia. The approach in Indonesia towards the financial crisis was to agree to the IMF extension of loans. And basically they set up the Indonesian Bank Restructuring Agency, which was a specialized agency which comprised private sector as well as public sector experts to help restructure, in particular, bad loans and to find solutions, right, to the banking crisis. Next slide, I deal with another country which took a different approach. You recognize the 2 famous Petronas towers, Malaysia. Malaysia at that time under Dr. Mahathir, the Prime Minister at the time, who recently resigned. At that time, he took a different approach. He decided that the IMF loans amounted to a colonial approach to colonize Malaysia again. So he rejected the IMF loans. He imposed capital controls in Malaysia, which basically invalidated the use of offshore ringgit. And the impact was not just economic, the impact was also political. If you remember, his Deputy Prime Minister and Finance Minister Anwar Ibrahim, following the disagreement on these 2 issues, publicly they spoke against each other, and the result was Dr. M prevailed and Anwar Ibrahim was sacked. And the rest is history. But Malaysia took the similar approach with Indonesia and several of the other countries to set up an asset management company. In this case, it was called Dana Harta, to manage non-performing loans. They also set up a company owned by central bank called Domino Model, which was used to raise funds to recapitalize the banks in trouble. Moving on quickly now to talk about the IMF loans. I won't go through this in detail in order to save time. I just want to highlight to you that the IMF loans came with various conditions. But to be fair, many of these conditions resulted in serious law reforms in terms of insolvency laws, resulted in reforms of banking systems and institutions, and including the discipline of allowing insolvent banks to fail or to merge and consolidate. And I think the useful lesson learned from the 1998 crisis came in handy when the global financial crisis hit in 2008. And you will see in history that many of the Asian countries managed to get through the 2008 crisis fairly well. But of course, there are also other reasons why Asian economies were not so badly affected by the global financial crisis. One of the reasons being that in the 90s, we were probably more reliant on the West for our trade and our exports. But I think by the 2000s, the emergence of China resulted in Asian countries getting business, investments, and trade with China. There was less reliance, not decoupling, but less reliance on the West. Next slide, please. And coming to the end of my presentation, I wanted to touch now very quickly on post-Asian financial crisis. Of course, there are many lessons to learn, but I just highlight four. One is clearly the banking system in Asia improved, as I just said. Two, the rise of deposit insurance agencies in Asia occurred after the financial crisis. Some were pay box style, which is, for example, Singapore, or some created resolution agencies like Malaysia, Hong Kong. The insolvency laws were reformed largely to a very large degree. And the idea of crony capitalism, there was a lot more discipline, was reduced. My second last slide. I would like to now quickly touch on the issues which have arisen as a result of this pandemic that has hit the world. I think most recently, I would say in Asia, there have been hardly any bank failures, but there are two notable ones to take note, which occurred before the pandemic. One is in China, Inner Mongolian bank called Baosheng, which is part of a large conglomerate called Tomorrow Group, which collapsed last year. And it was eventually, the bank was bankrupted. The shareholders lost all their equity. The business was sold to China Construction Bank and another provincial bank from Anhui. The second bank that collapsed last year as well is a bank in India called Yes Bank, which you will see both banks collapse before the pandemic, and both banks were seriously having large portfolios of non-performing loans which were not accurately reflected in their accounts until too late. I won't go into detail. I will go next to talk about Indonesia, where I think sometime in June, the Deposit Insurance Agency highlighted risks in relation to 8 banks. They later clarified that they were not saying the banks are in trouble, but that the banks are on a watch list. Indonesia also passed new laws in first quarter 2020 after the pandemic started, giving the central banks more power to order merger, consolidations, or acquisitions in the event that the central bank is of the view that there are issues with the bank's financial status. And you will see during COVID-19, many governments in Asia, I think even across the world, introduced a lot of stimulus measures. And the amounts were huge. You're talking about up to 25% of a country's GDP being poured out in terms of cash, tax rebates, and payroll support. Many countries, including Singapore, for example, had rules which limited banks in terms of the amount of dividends they could pay out. And in Singapore's case, they restricted it to 60% of last year's shareholder dividends. Okay, I'm coming up to my last slide now. I end with just two questions. I'm sure there are many questions that one could ask in terms of the lessons learned from the Asian financial crisis and so on. The first question is, what will be the impact on businesses and banks with the stimulus measures tapering off towards the end of this year for many countries in Asia? And the second question is, are Asian deposit insurance agencies adequate to fund the next bank collapse? My view on the first is it's uncertain. My view on the second is that I don't think there is enough. And the governments will probably be able to cope with minor collapses, but not, the deposit insurance agencies will cope with small collapses, but not mid to large size collapses, which will have to be handled with government guarantees in all likelihood. Thank you very much for listening. I'll hand you back now to Justice Feldman.
Thank you very much, Mr. Ng. One question, to what extent did cross-border issues that Mr. Bernstein mentioned feature in the resolution of the collapses and the restructuring of the financial institutions in Asia?
Yeah, that's interesting because I think even during the Asian financial crisis until now, you will see that most of the cross-border issues occurred mainly to collapses involving corporates with overseas businesses. But if you look at the Asian financial crisis, most of the banks with international connections were the large ones and mainly state-owned, and many of them were actually resolved with huge bailouts or support by governments. The recent collapses that I just mentioned in China and India were mainly local or provincial banks, and the impact actually was less in terms of cross-border issues.
So do you see that repeating itself now, or it's not clear?
That's a tough question. I wish I knew. I think it's quite unclear. I think quite clearly the banks are much better capitalized today than they were before, but it's anyone's guess as to how long this pandemic will be and the impact on businesses and banks. People are talking about U-shaped recovery, but they can't tell you how long the U-shape is.
Okay, well, thank you very, very much for those insights. I'm going to turn now to Professor Kanda, who's going to talk to us about the Japanese system and give us a couple of actual case studies that occurred. Please go ahead, Professor Kanda.
Thank you very much, Justice Feldman, and good morning, good afternoon, or good evening, everyone. It's my great pleasure and honor to be here and to be given an opportunity to speak. And so I'd like to thank the organizers for this precious opportunity. I will try to be quick. So Helen, please move to the next slide. I think I will talk about Japan, two cases, one that happened in 1998 and the other that happened at the time of Lehman, with Lehman, and then they would like to describe briefly the current bank resolution scheme in Japan. If time permits, I will have some comments on East Asia context and COVID-19 also. So please move to the next. Thank you very much. The first case I wanted to mention was the collapse of a very large bank in Japan called LTBC in 1998 for domestic reasons. It has nothing to do with the Asian financial crisis, which Mr. Ang just described. But this bank failed. And the Japanese government at that time decided to make it nationalized. But this bank was engaged in many swap transactions with foreign institutions outside Japan. The question, of course, was whether this nationalization is an event of default under the ISDA Master Agreement. The answer was not clear. What happened, however, the ISDA headquarters decided to make a public announcement, and they decided to issue a new press release from their New York website. Next slide, please. Can't read it, I'm sorry, this is, but anyway, basically says, the ISDA said, ISDA welcomes Japan's actions to restore soundness of its financial system. Because of this news press release, the so-called close-out netting did not happen. And this was the first case that we learned that the international coordination is very important. Next slide, please. So what are the lessons indeed? The impact of bank insolvency on global cross-border transactions is very, very important, and sometimes unintended things may happen. It is difficult to write every possible event in drafting a financial contract. So the uncertainty remains. Very important thing is to prepare against such uncertainty before an unexpected thing happens. So next slide, please. The case 2 is the Lehman case. Probably better to look at next slide. Helen, next slide, please. The Lehman Brothers had its 100% subsidiaries called Lehman Japan. It's officially Lehman Brothers Securities Japan. And it failed, and it filed official insolvency proceedings before the Tokyo District Court on September 16 of 2008. September 15 happened to be a holiday in Japan. And therefore, this Lehman Japan filed an insolvency petition on September 16 before the Tokyo District Court. The Nomura Securities, the largest securities house in Japan, is a 100% subsidiary of its holding company called Nomura Holdings, which is a bank holding company under the Japanese banking legislation. Still is another bank called Nomura Bank. It's officially called Nomura Trust Bank. It's also a 100% subsidiary of the same Nomura holding company. Now, here again, sub-transaction were pending and outstanding, and the close-out netting this time was operated between Lehman Japan and Nomura Securities, and then also between Lehman Japan and Nomura Bank. The result was that Nomura Securities ended up having a claim against Lehman Japan. The Lehman Japan ended up having a claim against Nomura Bank. The Lehman sued Nomura Bank for their performance for this obligation. Nomura Bank responded, well, you know, we are the same 100% subsidiaries of the same Nomura holding group. Therefore, we will exercise a set-off these two claims. Indeed, the Tokyo District Court recognized such a set-off, and Tokyo High Court affirmed it. But Japanese Supreme Court reversed and said, tough luck. The Nomura Bank is a different entity from Nomura Securities, and Japanese insolvency statute does not allow these three-party set-off, so to speak. And therefore, you need a special legislation if you want to change the landscape. Next slide, please. So what are the lessons? Well, surely, first lesson is legal personality does matter in Japan under judicial insolvency proceedings. And three-party set-off is not recognized under the insolvency proceedings in Japan. Well, you may say that you may write a contract in advance in dealing with the situations, but it's not clear whether parties may or can contract it out. And this situation still remains today. But this is a lesson we should prepare. So next slide, please. The current bank resolution regime in Japan, the current regime is based primarily on the international discussion at the Financial Stability Board, especially its famous key attributes. You will hear more about it in the US context, as well as perhaps remarks by Ms. Eva Helpkes tomorrow. The landscape of current bank resolution regime is highly complex. Next slide, please. This is, if you see toward the right half, it says item 1, P&A, item 2, 3, and so forth. These are the available measures for bank insolvency or resolutions in Japan. But in the lower half was added on the basis of FSP discussion, and as briefly described by Mr. Bernstein, and the two measures, item 1 and item 2, in the lower box, so-called orderly resolution measures in Japan, which are consistent with the FSB's proposal, as well as the counterparts in the US and other advanced nations. Fortunately, if I may say so, these measures have never and not yet been triggered to any particular case or banking institution. Next slide, please. This is the SPE model described by Mr. Bernstein. If the subsidiary A in the very lower left corner has trouble, and then the holding company should take care of it. This is a single point of entry approach proposed or considered at the FSB and was imported to the current Japanese scheme. Once again, fortunately, if I may say so, this scheme has not been triggered yet. So we're not sure what will happen if it is triggered in reality. Next slide, please. So what are the lessons? Well, the bank resolution involves both courts and regulators. That is the key thing. And generally, the court process takes time, whereas the regulators want a speed. So they have different mindsets. So how courts and regulators cooperate and coordinate should be the key to the success of a bank resolution process involving a large banking group. The cross-border context, more than one court and more than one regulators get involved. And the result is inevitably highly complex. As Mr. Bernstein explains, whether the courts, as well as I might say regulators in more than one jurisdictions, including both host countries and home country, can cooperate and coordinate should be the key to the success of the huge bank resolution process. When it comes to the cross-border context, both statutory approach and the contractual approach should be carefully explored, because one country might adopt special statute and legislation, try to stick it. Other country may perhaps want to leave it to market practice or the people's agreement, like it happened in the Lehman Brothers in certain contexts. So these things should be explored. And the details of the Japanese system as well as FSB will be written in various literature. On the last page of my slide, I think I cite my own article with my colleague Tomoyuki Hayashi, as well as FSB's document. 1 minute on East Asian context. Asian financial crisis did affect the South Korea, but not China or Japan, as Mr. Ang explained. The global financial crisis, not quite on Asia, of course, did affect market, but not systemic concern, systemic risk. The pandemic now, so far, no systemic issue, but future is uncertain. Therefore, I would say the importance of preparing an effective bank resolution system cross-border should not be underestimated. So Pia, thank you very much.
Thank you very much, Professor Kanda. So just following up on the current situation, do you see that the structures in the Japanese system are prepared for what may come as a result of this current COVID pandemic?
I hope so, but who knows, they've never been tested. So we'll probably have a big discussion in the later panels about the US system. The major systems in those countries, probably in Canada as well, I don't know much about it, to be honest, but on the basis of this FSB's discussion. So we will be hoping, of course, under the current pandemic, if something happens and raise a systemic concern, or more specifically, if a large banking group has trouble, then more surely these models like single point of entry model will be triggered, and we will see what happens. But the assumption, of course, is that we quite believe that the system and the current scheme should work properly, but we will see what happens.
Okay, well, it sounds very positive. So let's hope that's how it turns out, or that it doesn't have to be tested. want to thank my two panelists very, very much for their insights into the Asian situation. Now it's time to turn it over to Justice Fitzpatrick to deal with the North American situation. Thank you.
All right.
Thank you.
Thank you, Kathryn. This is Shelley Fitzpatrick speaking. I'm a judge on the British Columbia Supreme Court. Welcome to our panel, which is, as the slide you'll see indicates, turning from Asia. We're now going to turn to North America. And I have a wonderful panel that's about to provide some insights into the North American recovery and resolution systems. Just briefly, by way of introduction, I'll start with Robert Sanderson. Bob has been a fixture on the Canadian insolvency scene for many decades now. He has started his career with KPMG, and he's held various important positions with CARP and the IIC. He is presently the chair of the board of directors of the Canada Deposit Insurance Corporation, or CDIC. So he now provides a regulator aspect to his views. Then we have Dr. Maziar Peihani. Dr. Peihani holds the Lawson Lundell Professorship of Business Law at University of British Columbia, and he teaches in the field of financial and business law, including banking regulation, resolution of cross-border bank failures, sovereign debt restructuring, and disclosure and governance of climate-related financial risks. Next, we have Mark Lemieux. Mark brings us the practitioner point of view, the law firm practitioner. He's been a lawyer since 1988 in Quebec, one of the Canadian provinces. And he has been practicing in the area since that time. In 2015, he's started his own boutique law firm, and he now specializes in the legal needs of users and suppliers of financial services. He's also an adjunct professor at McGill University in Quebec. The counterpoint to the Canadians is provided by Professor Edward Janger. Professor Janger is the David Barse Professor of Law at Brooklyn Law School. Professor Janger joined Brooklyn Law School in 1998, so he has been working in this area for a long period of time, and he has written extensively in the areas of value allocation and governance in Chapter 11 cases, cross-border bankruptcy, resolution of systemically important financial institutions, of course, and the treatment of financial contracts in bankruptcy. So I'm going to ask Bob Sanderson to lead off the panel, and take it away, Bob, please.
Thank you, Justice Fitzpatrick, and thank you for the opportunity to speak to you today and share some insights into the Canadian experience. I'm going to cover, if you can go to slide 2, 3 areas really. Our mandate, and I'm going to cover that because it's important. If you understand our mandate, it frames all of the tools and how we apply them. So it's always useful to keep that in mind. And then I'm going to have a few remarks on the resolution of adhesive and cross-border cooperation. Next slide. Our mandate is set out in section 7, and it is our legal authority and, if you like, our command. It has 2 primary parts: the insurance against the loss of deposits. We are to contribute to the stability of the financial system in Canada. And we are to pursue those 2 objects with a view to minimizing the exposure of the corporation to loss. These all have equal weight, and so therefore we need to balance the 3 tests that are set out in the first part of our mandate. And lastly, we are the resolution authority for all of our members. This was a new provision that was added in 2019. Next slide. Our membership is broad. We have 86 members, small compared to many countries, but highly concentrated, with there being 55 financial groups. We are also the home to 6 domestically important systemic banks, 2 of whom are also GSIBs. In our 50 years, our mandate has evolved. We started out in our first number of years as essentially a pay box with a limited mandate and a limited ability to use what are now referred to as our Section 10 powers. From 83 to 87, we had a particularly active time with 20 of those 43 failures. And the result was that in 1987 and in the period from 87 to 2009, CDIC's role has morphed and changed more than at any other time to become more preventative and independent. And of course, starting in 2009, we were responding to our lessons from the financial crisis. Slide, thank you. So we have, you can see in this time spectrum that in 1992, we added to our capacity the recapitalization tool. And in 2009, the ownership restrictions were amended to give us increased flexibility. In 1996, the FIRP powers, financial institution restructuring powers, were added, which are critically important because they allowed us, where there was a pending sale or transaction that might otherwise allow the institution to continue to operate in a normal manner, we don't need to go through the sort of the corporate regime to affect the transaction. We can actually force that transaction. So that was a big step. In 2009, we added the ability to use Bridge Bank. And in 2016, we brought in open bank restructuring, EFIRP, and bail-in. And I will spend a few more minutes looking at bail-in on the next slide. So for bail-in, which came in 2016, this involves CDIC taking temporary ownership of the shares or the assets through our EFIRP powers. And we can use EFIRP with or without bail-in. So our tools can be mixed and matched to allow us to come up with the solution that is going to fit the purpose and the situation that we face ourselves. And in listening to Bernstein's presentation, I was reminded of the fact that it's vitally important for these regimes to adapt and be consistent with the framework within each jurisdiction. It gets complicated where we have multinational or global institutions, and more on that later. Now, my co-panelist, Maziar, is going to discuss some of the mechanics of bail-in, but I would like to spend a couple of minutes covering off the no creditor worse off concept. This was added in 2016, and it applies not only in a bail-in, but in any resolution, essentially, that is undertaken. And the whole, next slide, and the, sorry, has been made worse off as a result of their actions than they would have been in liquidation. Now, the concept is you, on the date of, quote, failure, you would measure the value on a liquidation basis of the institution and compare it to the value that the various creditors received, including shareholders. If the liquidation value turned out to be greater, then there is compensation paid. If it isn't, there is none. But the idea is to give us the flexibility to take the action that meets our 2 mandates, protecting depositors and in contributing to the financial stability. And so therefore, there will be times when, using the loss minimization waiver that was granted to us in 2016, are to take a position which might put a shareholder or a creditor that otherwise would have got something in liquidation in a different position. I would encourage you for both this concept and any of our resolution tools to visit our website and look at the detailed offerings that we have in that presentation. Over the past number of years, we've worked with DSIBs and the other market authorities and participants in Canada to explore the operational details in implementing the bail-in and other resolution tools. This has led to a very cooperative approach. There is general agreement on the sequence of steps and the information requirements, and this culminated in us publishing our resolution bylaw in 2019. Don talked about cross-border cooperation. To me, this is one of the most important aspects of work that has been done over the last 10 years. And CDIC has been an active participant in engaging and in working to ensure cross-border alignment. As you can see, we have memorandums of understanding in over 30 jurisdictions, and we regularly play host with OSFI to crisis management groups. Next slide. And that's it. Thank you very much.
All right, I'd ask Dr. Peihani then to give us his thoughts on the matter, please.
Good morning, everyone. Thanks very much to the organizers. It's an honor to be here. So I'm going to speak a little bit about the bail-in regime in Canada from a comparative perspective. So I'll draw some comparisons between Canada and United States and also BRD, the European framework. So in Canada, as Mr. Sanderson mentioned, the bail-in regulations came into force 2 years ago, actually September 2018. And the Canadian DSIBs, the systemically important banks or the 6 largest banks in Canada, they have to issue bail-in debt. And as you know, bail-in constitutes a part of the TLAC, and the TLAC, the average TLAC in Canada was about 19% at the year end of 2019. But the regulatory target is higher, it's about 23.75%. The original deadline was November 2021, but because of what's going on with COVID, it may be extended. In terms of the market perspective, issuing bail-in hasn't affected the Canadian banks' ratings, but the bail-in instruments themselves have a lower credit rating, which reflects the risk of a higher loss absorbing, which could happen in a bank resolution scenario. And any trade and distribution of the bail-in instruments, they have to be done through registered dealers, which are regulated by Provincial Securities Commission. In terms of conversion of the bail-in debt, so as Mr. Sanderson mentioned, it's part of the broader restructuring regime in Canada. So the way it happens is that the federal cabinet or the governing council issues a restructuring order, and then it vests temporary control and ownership of the firm in CDIC. And then using the bail-in is absolutely within the CDIC's discretion. So we don't have a provision similar to the BRD, which requires a bail-in of 8% of liabilities before injecting any public funds. In other words, the Canadian regulators are under no obligation to use the bail-in regime. So it offers a lot of flexibility to the CDIC. In terms of the amount of conversion, the CDIC is free to establish the size of the bail-in and the conversion rate. The only interesting thing to notice here is that the CDIC has the power to convert bail-in instruments into equity, but it doesn't have the power to write down the liabilities. So this is one different aspect compared to other resolution regimes around the world. And as Master Sanderson also mentioned, bail-in is subject to the no creditworthiness of principle, which I think could actually give rise to certain a number of problems in a resolution scenario. So now I'd like to talk a little bit about resolution funding. As all of you know, bail-in is only the first step in recapitalization of the firm. And successful recapitalization needs provision of liquidity and additional funding. So who could do that in Canada? Well, the CDIC, as you know, is both the insurance both the deposit insurer and resolution authority, which means that both functions in Canada are combined. So the corporation could use the deposit insurance funds to fund resolution. Its capacity was $4.5 billion, basically the investment portfolio that the corporation held as of June 2018. But it also has legislated borrowing capacity of up to $24 billion. And this limit could be also increased if it's required, but it requires parliamentary approval. The other important player that I would like to briefly mention here is the Bank of Canada. So historically, the Bank of Canada intervention would be governed by the lender of last resort operations. And in Canada, that's called the emerging lending assistance. The bank has revised its ELA framework in 2015. I would like to mention some of the important changes. One is that the traditional solvency requirement has been replaced with credible recovery and resolution planning. The bank itself doesn't specify those requirements, so it defers to the CDIC and the prudential regulator. But a number of things that the bank looks at in determining whether or not provide liquidity is whether the bank can maintain critical functions, such as which are important in terms of financial stability, whether the bank has sufficient funding and liquidity management in place, and whether it has effective coordination and information sharing in place with authorities. And the other interesting thing that the bank has done is that it has expanded the range of instruments that can be pledged as collateral. So now you could also have Canadian dollar non-mortgage loans pledged as collateral, and also Canadian mortgages, even though it could be legally a little bit complicated, but there is a way to work around that. So I think overall, the Canadian approach to liquidity assistance and resolution funding is a little bit less convoluted and easier than the US approach. The Dodd-Frank, as the American colleagues all know, has significantly constrained the ability of the Federal Reserve to provide liquidity to a banking resolution. So what you have instead is a pretty much convoluted procedure under the Dodd-Frank that the FDIC can borrow from the orderly resolution fund, and the OLF is actually run by the Treasury, which is a fiscal authority. But then the Treasury, you look at their documents, they say that they're going to rely on the Federal Reserve policies and the discount window policy, which is again principles of central banking. And I think setting aside all these particular issues, I'm not sure if the discount window could be the right policy, in the sense that it usually relies on investment grade securities that could qualify as collateral. And in a stress market scenario, some of the banks may not be able to find collateral. So I'm going to stop here and then also save some time for questions, perhaps. Thank you very much.
All right, thank you, Dr. Peihani. All right, well, I think I'll turn the matter over to Professor Janger now with that comment about the convoluted. I'm sure he's going to respond from the American perspective, and we're treated to a wonderful view. I don't know whether that's Manhattan or Brooklyn, but Professor Janger, take it away, please. I think you're still on mute.
Yes, so that is, I live in Brooklyn Heights, so that is the view of Manhattan from Brooklyn, not exactly where I'm sitting, but nearby. Well, thank you for including me in this extraordinary event, and I have the distinct honor and punishment of talking about the US system after Don Bernstein has already gone first. So what I want to do before I start raising concerns about challenges is to thank Don and quite frankly, a large number of people for basically making the system in the US considerably better. And so while I'm going to be looking at some concerns, I really do think that it is a glass 3/4 full situation. What I'm going to do is focus on several distinct aspects of the US system that interact to raise concerns about how we can do better. The distinct aspects are that we have multiple fora for resolving different types of financial institutions that plays into a rhetoric of bailout versus bankruptcy. The second aspect is that we have focused almost exclusively on SIFIs and GSIBs, and those two things interact to raise a couple of concerns that I'd like to talk about. Next slide. So in the US, we tend to focus from the banking side on banks and SIFIs, but there are two fora that operate in the financial resolution regime. We have the administrative track, and then we have the bankruptcy track. And the thing that is a little bit tricky is that banks follow the administrative track under the FDIC. Non-bank financial institutions use bankruptcy, and SIFIs post Dodd-Frank end up using either bankruptcy or the OLA, depending. Next slide. So, all right, perfect. What I'm going to first talk about is how we've done really an excellent job in the United States of fixing the SIFI problem, but also to highlight an aspect of how that was done that has created some issues. Next slide. Oh, next slide. Okay. No, back up one. There we go. Perfect. In the wake of the 2008 crisis, there was a tremendous rhetoric of no further bailouts, and therefore financial institutions ought to be allowed to use bankruptcy, to go bankrupt. That has played out in a political hostility to the administrative track, a political hostility to the lender of last resort concept that Don had talked about, and an imperative that, other things being equal, SIFIs should use bankruptcy court rather than the administrative track. Now, that has led to a remarkable effort by people like Don and others and the FDIC to create a resolution planning regime that plans for resolution in bankruptcy court. And that is the bail-in structure that we refer to as single point of entry. Next slide. I've stolen, actually, Don and his partner Randy Gwynn's diagram, because this is perhaps the best picture I've ever seen of how the structure works. So this is the single point of entry strategy, where you have a bank and then a number of operating companies. And next slide. And the concern, one more, back up, too fast, wrong way. There we go. The concern is that there might be a shock at an operating company level, and that the bank holding company, next slide. Perfect. The bank holding company will serve as a source of strength to recapitalize the operating company with no disruption in operation, and therefore create market confidence. The hope is that the bank's total loss absorbing capacity will allow it to serve as that source of strength without needing to be formally resolved. But if it does, there is the idea that it will be resolved in bankruptcy. Next slide. And that the bank holding company will transfer the stock of the operating companies to a new bridge bank, and the old creditors will be converted to shareholders, and the newly recapitalized holding company will go forward into the future. This is a classic bail-in structure, and the hope is that it would be able to be implemented in bankruptcy. Next slide. There were some concerns, and there remain some concerns, this is important for the international point, which is almost all of the worry is about confidence about the capacity of the bankruptcy courts to handle these instead of administrative agencies, and concerns, as Don mentioned, about the bankruptcy code's safe harbors, which do not permit or stay and do not allow time for the creation of a bridge bank transaction. That created some international confidence, both in the institutions and further, as Don pointed out, confidence in the allocation of the total loss absorbing capacity in the system. Oops. Next slide. So the good news, and this I say from the US perspective quite wholeheartedly, is that the FDIC has done an excellent job of coordinating and educating judges on how to handle these cases. The bankruptcy judges that I'm aware of are extraordinarily familiar with these issues and prepared for these cases if they should happen to end up in bankruptcy. The other good news, at least for SIFIs, is that the safe harbors have been dealt with through the use of the ISDA protocol and concerns about flexibility, about solvency have been dealt with through the intermediate holdco. Is there a residual amount of concern? Internationally, it strikes me that there may still be concern about bankruptcy court capacity, and that this may lead to the need to, or the likelihood that most of these SIFIs will still be resolved using the administrative track. And the second challenge that remains is the ring fencing challenge that Don mentioned. Next slide. What I want to focus in on, though, is two things that I think remain problematic in the US system. One is well, actually, let me back up one second. Two things that are problematic in the US system. One is the fact that this solution has been almost entirely focused on SIFIs. And the second is the fact that there is this huge discomfort with lender of last resort. And those two things are creatures of and residual effects of the politics of bankruptcy in the United States, which is this fear of bailouts and the focus on bankruptcy court resolution. Next slide. Okay, so let me see if I can do this in the couple of minutes remaining to me. One of the solution that is currently in place to deal with the problem of runs and the problem of financial contract closeout is the ISDA protocol that Don described. That ISDA protocol has been signed on by all SIFIs. It has expanded its scope over time. In addition, the administrative track also provides a stay. But there is a hope that bankruptcy courts will get the benefit of Chapter 14 or Subchapter 6 to make this a statutory solution rather than a contractual solution, but it hasn't happened yet. Further, the focus of the statutory solution is SIFIs, which is to say large institutions of 500 billion capitalization or more. And one concern that I have is that not all financial institutions are classified as SIFIs, and it is possible that, that systemic risk can exist on the border of the SIFI category. A second concern is that some operating entities, if the TLAC structure fails, may still need to file for bankruptcy. And the third is that not all financial institutions are part of a SIFI structure and may fail. With all of those things, the fact that we still have this balkanization between bankruptcy and OLA remains somewhat problematic, and I think a source of some lack of confidence in the US system. Almost all of that would go away if, and this is, if there were a reliable assurance of lender of last resort. The orderly liquidation fund is present. Hopefully it is sufficient and hopefully it will work. But we still have this schizophrenia in the US about bailouts, and that has, and I'll just wrap it up there, left us with a little bit of work we still need to do. Thank you.
All right, thank you, Professor Janger. Mark Lemieux, I'd ask you to please give us your presentation.
Thank you, Madam Moderator, and thank you for the organizers for extending a place on this panel for me. And my contribution here would be to highlight tools that we have in Canada for the resolution of clearing and settlement systems that complement the tools that we have for bank resolutions that my fellow panel members talked about. And the first key attribute that the Financial Stability Board puts out on its list of effective attributes for effective bank resolutions is the ability to ensure the continuity of important financial services and payment clearing and settlement functions. Why would that be the first key attribute of effective bank resolutions? Well, in Canada as elsewhere, you know, banks are connected to other banks in bilateral relationships, but as well in systems that facilitate the clearing and settlement of payments, securities, and derivatives. So what my first slide shows are the main clearing and settlement systems in Canada. LVTS is a system for the clearing and settlement of large value payments. CDSX, clearing and settlement of securities. CDCS, repos and fixed income. ACSS, a retail payment system that we have. CLS Bank and SwapClear, respectively, for FX and interest rate swaps. The numbers on this table, you know, might look municipal in range for a Chinese audience. They may look statewide in range for Ed in the US, and perhaps our fellows in Australia might look at them with some familiarity. What happens in these systems, of course, is that the insolvency or the operational impairment of a single bank can propagate to others, and so make the work of the bank resolution authorities more complex because of more patients to cure. So I'll be talking about a statute that we have in Canada, which is called the Payment Clearing and Settlement Act, or PCSA, which was enacted about 20 years ago and which manages these risks in Canada. And I'm going to be focusing on two approaches that the PCSA takes to do that. The first one being its power to designate payment clearing and settlement systems, or actually clearing and settlement systems of payments and derivatives and securities, to designate and oversee the functioning. And then the other approach would be a resolution tool. CDIC is one of two authorities for the resolution of financial institutions in Canada. The other complementary one for payment systems would be the Bank of Canada. So we could move to a second slide, but I wanted to give participants a bit of a visual break here with the rest of the slides. And so I won't be presenting the points, and I'll just use this painting of a Canadian painter, Jean-Paul Rietel, to illustrate networks. And so that should be a good backdrop for the rest of the conversation. With respect to the first point, the PCSA gives the Bank of Canada the power to designate systems that present systemic risk or payment system risk. Systemic involves insolvency, the ability to financially settle. Payment system risk refers to operational impairment. And the systems identified on the first slide have all been designated. most of them as systemically important systems, except for ACSS, which is a prominent payment system offering payment system risk. Let me just share quickly the story of the first designation of a system, which was at the time of inception of the PCSA. At that time, Canada had a single clearing and settlement system for payments, the ACSS, which was a legacy system. And as in the mid-1990s, awareness rose internationally as to the risks payment systems present to national financial markets and economies. And that's the context in which the PCSA was adopted, and at the same time, the Canadian Payments Association, who was operating the legacy system, extracted all large value payments from the legacy system to transfer them to a new system that had just been created for the occasion, which was LVTS. And why was this done? ACSS is a system where the rules are such that upon the default of a participant, all the remaining participants share in the loss. And of course, that's the kind of rule that assists in the propagation of insolvency, because if another participant is unable to foot the higher bill that this additional obligation imposes, well, then you have exactly what you want to avoid. LVTS is built differently, where really every dollar that's transferred in there is covered by collateral, such that at the end of the day, if a participant became insolvent, there would be what would be required in the basket to honor the settlement obligation. So LVTS is just a more robust payment system. And enhancements like these have been brought to the other clearing systems, okay? So this shows a step that was taken 20 years ago that I would think helps bank resolution today. For the remaining few minutes that I have, I just want to say a word on the provisions in the PCSA that deal with the resolution of settlement and clearing and settlement systems. Which, by the way, you know, what I'm giving to you, if you go on the website of the Bank of Canada, you'll see their information and links to relevant documents. Anybody wanting support for what I'm sharing with you right now. The resolution regime for clearing and settlement systems is based on the same international guidelines developed by the Financial Stability Board, with which you would be familiar. Our resolution regimes only applies to systems located in Canada. So if you remember the list on the first slide, CLS Bank and SwapClear would be two clearing systems that are foreign to Canada, meaning located outside of Canada, but in which Canadian participants participate. Conversely, in our domestic payment system, Canada is an open banking place in the sense that foreign banks can do business in Canada. So we have foreign participants that play in Canadian systems. And the way the PCSA deals with those two things is as follows. Canadian participants that are participating in systems that are foreign can benefit from the rights under the PCSA if they comply with the obligations in there. So the idea is not to regulate the foreign system, but to be interested in the foreign system to the extent that it clears in Canadian dollars. With respect to foreign participants in Canadian clearing and settlement systems, there are entry-level requirements that include the production of legal opinions respecting the laws of the home jurisdiction and what would happen should there be any problem with that particular participant. The basic elements of the resolution regime are similar to bank resolution: appointment of a resolution authority, preparation, initiation, performance, and exit. With respect to preparation, this is all very new. The guidelines for this have been published in the month of June, which is, you know, an homage to the way the central banks have been busy since the beginning of the pandemic. It's busy now. The Bank of Canada is preparing resolution plans for each of the Canadian clearing and settlement systems. This will be a process where consultation, not only with the systems, but as well with other regulatory authorities will take place. The resolution is initiated with a declaration of non-viability by the Bank of Canada. And really what that means is either financial inability to settle or a major operational impairment of the system. These declarations of non-viability, they don't come out of the blue. There's an oversight system by the Bank of Canada, and oversight results in the systems having risk management controls and recovery plans in case of stress event. And so it's expected that a system would only be declared non-viable after the Bank of Canada has witnessed that its controls and recovery plans have failed. With respect to performance and exit, maybe a short word. There has been talk about funding, and so for the purposes of financing the resolution of a clearing and settlement system, the Bank of Canada is allowed by the PCSA to borrow from Canada's consolidated revenue up to $3.2 billion. And this amount is said by the bank to have been tested to be sufficient to deal with the simultaneous resolution of all current Canadian clearing systems. Ultimately, the financial responsibility for the cost, the resolution cost, would lie on the system participants, and the system's equity holders. Maybe just one word in closing before we engage in any questions. We have, or the resolution system for clearing and settlement systems also have a worse off provision, meaning that where that would be necessary to ensure that participants or equity holders are no worse off than they would have been in a winding up scenario, compensation may be allowed to them under this resolution system that I have been discussing. I think I'm done with my time, Madam Moderator, so perhaps we're good for questions.
Okay, thank you, Mr. Lemieux. All right, well, we're almost at the end of our presentation. We've only got a few more minutes, and we did have a number of questions. But so I'm going to deal with it this way. Professor Janger, since you were a bit outnumbered on this panel, I'm going to give you the privilege of choosing what you think is the most pressing question that the panelists would like to or need to answer. So I'll let you pose one of your questions, one of which I think was controversial. And then everyone can weigh in just very briefly, please.
Yeah, so I hope I remember, I hope I'm gonna ask the right one. It's a bit of the bad date story, which is enough about me, what do you think about me? Which is to say, the US system straddles administrative and judicial resolution regimes. And I was just wondering if we could get a perspective from the outside perspective about the how that changes the dynamics of that choice might change the dynamics of a resolution case, because it's not a US only situation where you've got multiple jurisdictions that have that.
Bob, do you want to weigh in on that?
I think I may have asked that in the way that Bob didn't want me to ask it.
Let me, on one level, Canada also has both an administrative and a court process. Because it is possible under where we've done a FERP or we've done a bail-in, where there is a residual entity, if you like, we could, that could find its way into administration under the Winding Up and Restructuring Act. So the challenge that I see is from a cross-border point of view, because the one thing about working through administrative proceedings on a multinational basis is that the individuals who are most likely to be involved in executing on that have an opportunity to build relationships and trust with each other that allows them in periods of high stress and rapidly changing circumstances to potentially respond much more nimbly and quickly than if we're having to involve ourselves in a court process where the actors may not be as well known, and the level of experience, maybe notwithstanding the Southern District of New York Bankruptcy Court, may not be quite at the same level.
All right. Well, thank you, Bob. I think our time is up, unfortunately. So Mark and Maziar, unfortunately, I'm not going to have an opportunity to ask you to weigh in on it, but I want to extend my thanks to all four of our panelists. Thank you very much for your very insightful comments. And now I'll turn the matter over to Justice Paquette for the presentation of the panel that she's chairing.
Thank you all.
So good morning, afternoon, evening, or night, depending on where you are. I don't know if you hear me well. I hear no screaming, so I presume everything is okay. So I am Marianne Paquette. I'm from Canada, and I'm a judge at the Quebec Superior Court, of which I am the coordinating judge for the commercial division. Now, if the simple reading of the title gave you a headache, the title of our panel being the treatment of structured financial products during financial institution resolution, I may share with you that you are not alone. You and I share a place in a probably tightly packed boat. But that being said, I'll do my best as the chair of this panel. And the failure of financial institutions operating across multiple international jurisdictions, as you know, raises multiple issues, particularly with regards to the treatment of structured financial products. Luckily, the Colloquium team has gathered impressively knowledgeable professionals to assist us in better understanding not only the title of this panel, but also the actual issues behind. So we will start with Professor Stephen L. Schwartz, a Stanley Art Star Distinguished Professor of Law and Business at the Duke University School of Law in the US, North Carolina. He will first set out the basics, and he will provide the overall context for why we focus on insolvency closeout netting. He will discuss the impact of the reach of bankruptcy law on the derivative market. Following that, Dr. Riz Mokal, a leading commercial law barrister at the South Square Chambers in London, UK, will expand on closeout netting and will discuss the domino model of contagion and systemic risk. After which Professor Anna Galpern, who's a professor of law and research professor at the Georgetown Law University in US, Washington, DC, he will elaborate on the interactions between the private actors and the public regulations, and on the inefficiencies inherent to that landscape. We saved approximately 10 minutes for an open discussion at the end of their individual presentations. So feel free to throw in your questions to them using the chat function, and we will have our panelists deal with those questions at the end of their respective presentations. So it's cloudy here in Montreal this morning, so I am tempted to say at this point, Professor Schwartz, time to shine.
Thank you, Justice Paquette. I'm actually speaking from Long Rock, North Carolina, in the middle of the Blue Ridge Mountains, and it's beautiful here today. So when I first saw our panel's topic, treatment of structured financial products during financial institution resolution, I wondered how we possibly could focus it for a 40-minute presentation. The term structured financial products can broadly mean any investment securities whose return is linked to underlying assets or to an index. And the term sometimes is used to describe those securities if derivatives are involved. But however one defines the term, there are also many interesting questions about how one should treat structured financial products in financial institution resolution. So these include, for example, which of those products qualify for the bankruptcy law derivative safe harbor, whether those products could actually be recharacterized in financial institution resolution, and how derivatives should be treated in resolution, including insolvency closeout netting. So we focus today on this last question. Insolvency closeout netting is a special type of netting or offsetting of derivatives obligations. It allows a derivatives counterparty, upon the occurrence of an insolvency proceeding or default relating to the other party, and I'll use the terms insolvency and bankruptcy interchangeably. So upon the occurrence of that default, to terminate outstanding obligations and reduce the amounts mutually owing between the parties to a net amount. Closeout netting typically is authorized by contract, but its enforceability in an insolvency proceeding would be subject to the relevant jurisdiction's insolvency law. And that's because enforcing netting would prevent claims and assets from being drawn into the insolvent debtor's estate, instead making those assets immediately available for the netting creditor. Now, the primary argument in favor of enforcing insolvency closeout netting is that it may reduce systemic risk to the stability of the financial system. The underlying assumption underneath that argument is that derivatives markets cannot function if stays are imposed by national insolvency laws, because the failure of a derivatives dealer would lock counterparties into long-term positions of constantly changing value. Closeout netting, in contrast, enables solvent counterparties to quickly resolve derivatives positions and reduce their risk by assuming net positions. However, there also are arguments against enforcing insolvency closeout netting, and these include that its effect on insolvency generally. By dismembering parts of the insolvent debtor's estate, netting shifts the counterparty risk to the debtor's other creditors, and that undermines the pari passu principle of recovery. Also, closeout netting may encourage moral hazard. It reduces the incentives of market participants to closely monitor counterparty risks. Furthermore, there is even the possibility that insolvency closeout netting inadvertently can increase rather than reduce systemic risk. For example, a major derivative counterparty's default could enable its counterparties to engage in closeout netting, and that could force the liquidation of assets. And there would be a multiplied instability that I'll discuss in a few minutes. Now, there is confusion, essentially, about the actual consequences of insolvency closeout netting. And that confusion reflects its path-dependent genesis. It started from back when the US Bankruptcy Code was first enacted in 1977, effective in 78. And there was a lobbyist who basically said, we need a safe harbor for derivatives. And Congress put a very small safe harbor in, and every few years that was increased on the theory that, look, we had the safe harbor, and as a result, we haven't had a crisis. And so there's a long path-dependent history. Now, the fact that the safe harbor that allows insolvency closeout netting and other types of contractual enforcements in insolvency, the fact that those exceptions are path-dependent does not necessarily make them bad. However, if we consider the exception and insolvency closeout netting from the standpoint of the three most significant determinants of systemic risk, interconnectedness, size, and substitutability, that might provide some insights. And I'll also briefly touch on potential lessons from Lehman Brothers. So first look at interconnectedness. Insolvency closeout netting does not appear in a meaningful way to protect against systemic risk resulting from interconnectedness. Indeed, by permitting derivatives positions to be adjusted by executing offsetting positions with the same parties, insolvency closeout netting actually allows participants to concentrate their positions with relatively few dealers. And that concentration increases interconnectedness. Interconnectedness can trigger the very types of liquidity crises that can spread a chain of defaults among financial institutions. It also can trigger fire sales and liquidity shortages. Professors Edwards and Morrison contend, for example, that closeout netting would have motivated long-term capital management's creditors to rush to net and close out their positions. And that in turn could have caused or exacerbated liquidity shortages that would result in systemic illiquidity and widespread contagion. Next, consider the second most significant determinant of systemic risk: size. Insolvency closeout netting incongruously operates independently of the size of the counterparty or its portfolio. Furthermore, it applies not only to financial firms, but to any firm that holds a derivative. By failing to take systemic importance into account, insolvency closeout netting appears to extend well beyond its purported rationale of reducing systemic risk. The third most significant determinant of systemic risk is substitutability or lack thereof. And this refers to the ability of components of a system to provide the same or similar services in the event of a failure. From a systemic risk perspective, the danger is that a component of the financial system, in this case, the derivatives market, performs a critical function that, if it fails, could not be replaced in a timely manner. And I think that this argument is not compelling because derivatives roughly have two functions: to hedge against risk and to speculate. Speculation is not a publicly desirable goal, and hedging against risk can often be provided through insurance. And in any event, insolvency closeout netting does not protect against systemic risk caused by the lack of substitutability. Finally, let me at least suggest two possible lessons of the bankruptcy of Lehman Brothers. First, how does Lehman Brothers being forced into bankruptcy inform the closeout netting debate? I think this question has effectively been answered. When a derivatives counterparty is a defaulting counterparty, the safe harbor enables the dealer's other counterparties to enforce their remedies, thereby hastening the dealer's collapse. And this at least partly explains the run on Lehman Brothers, which triggered its bankruptcy filing. More generally, the safe harbor, including its unrestricted closeout netting, motivate counterparties to engage in this type of run on a derivatives dealer, which has parallels to a bank run. And to that extent, insolvency closeout netting can possibly amplify systemic risk. The last question is, how does Lehman's actual resolution in bankruptcy inform the closeout netting debate? The answer to this question, I think, is less certain. A Federal Reserve Bank of New York study attempts to provide an answer, but even given closeout netting, the authors find that most counterparties of Lehman's over-the-counter derivatives suffered substantial losses, but they conclude that Lehman's bankruptcy involved so many competing variables that they cannot really ascertain to the extent to which closeout netting contributed to counterparty recovery or systemic risk. They also point out, however, that insolvency closeout netting facilitated the cherry picking of derivatives contracts, and this had a mixed impact on recoveries. In the money, counterparties of Lehman generally used it to terminate their derivatives contracts early. Out of the money, counterparties who owed money to Lehman under their contracts typically chose not to terminate their contracts early. And as a result, the settlement of Lehman's over-the-counter derivatives claims may have resulted in significant losses, not only to Lehman, but to its other creditors. And many of those creditors were themselves systemically significant. So in short, there is unresolved controversy. I know that, Riz and Anna will talk more about it, about the consequences of enforcing insolvency closeout netting. And for that reason, the Financial Stability Board's key attributes recommend that resolution authorities should be empowered to impose a temporary stay on the termination rights exercisable under closeout netting, the rationale for which is to allow time to determine whether the closeout netting would frustrate the orderly implementation of resolution measures. Thank you. Riz, I think you're up.
Thank you, Stephen, and thank you, Justice Paquette. It is an honor to be part of this program, and it is a pleasure to be able to draw, if we could go on to the next slide, please. It is a pleasure to be able to draw on work I'm currently doing as part of the Bowen Island group, which consists of legal professionals from diverse backgrounds named here, and which is currently supported by the III and others to investigate the feasibility and possible contours of a model law relating to the cross-border resolution of financial institutions. And tomorrow's panels will draw out some more of this work. If we go to the next slide, please. Let me give you a quick overview of my presentation as you look at the map location of Bowen Island, a slice of heaven off the Vancouver coast and the home of two of our members, Professors Janice Serra and Ron Davis. As Stephen explained, the treatment of closeout netting is justified on the basis that it mitigates systemic risk. I propose to examine the model of systemic risk underlying this approach, and this is the domino model of contagion. I will contrast this domino model with a different approach, which revolves around so-called asset value contagion. And I will argue that the treatment of closeout netting underplays the actual dynamics of systemic contagion, and that it ignores the ways in which systemic risk crystallizes into systemic crisis. What is more, and going further than Stephen in his characteristically careful way has done, I will argue that the focus on the domino model in the construction of the financial resolution architecture has obscured those actual dynamics of systemic crisis and may even have exacerbated rather than mitigated systemic risk. Next slide, please. Stephen has introduced closeout netting up to the global financial crisis, and even to date, this mechanism is accorded a privileged position under well-developed bankruptcy and bank resolution frameworks. My focus is on the ability of counterparties benefiting from these privileges effectively to ignore the moratorium on claim enforcement against distressed institutions and to be able to terminate contracts with distressed institutions and to be able to liquidate collateral. These privileges are enshrined in the US Bankruptcy Code, for example, and in the EU Financial Collateral Arrangements Directive, which is part of the laws of all EU states, including the UK, which has announced that even after Brexit takes effect at the end of this transitional period, it will continue to enshrine these privileged immunities for closeout netting. Going to the next slide. Here is the canonical statement of the domino model as found in the UNCITRAL Legislative Guide on Insolvency Law. The basic notion is very simple. Failure of one institution to meet its obligations triggers a similar failure by one or more of its counterparties. Now, I would ask you immediately to note two things. First, the model's focus is exclusively ex post. That is, it focuses at the point at which a financial institution is already distressed. The distress of one institution thereby causes the distress of another. However, systemic risk in the financial sector, I suggest, is not merely a function of the distress of one or more institutions. Instead, it is obviously and powerfully affected by the behavior of financial institutions, their decision makers, investors, counterparties, regulatory and even monetary authorities and others in good times, in times where the system does not obviously suffer from a distress, let alone a crisis. But the domino model has nothing to say about any of that ex ante perspective. Next slide. Second point is that the domino model of contagion ignores asset value contagion. This is a phenomenon that Don Bernstein already touched upon in his remarks. Asset value contagion is a collective action problem in which an asset price shock, such as that resulting from the bursting of an asset price bubble, causes balance sheet constraints on asset holders to tighten. And those asset holders then throw those assets into the market, liquidate them in order to raise capital. And this lowers asset prices further, and so on and so forth. So when the supply of a particular type of asset increases, other things equal, the price falls, and this places other financial institutions holding the same types of assets in that more constrained situation. This contagion may operate through forced sales of assets because of pressures in relation to any or all of leverage, margin, collateral, or capital. And in each case, the amplification of systemic risk by which a crisis may eventually be eventuated results from individually rational attempts to liquidate assets, but this triggers price collapses and thus systemic disaster may result. Now, this is not a new discovery. Irving Fisher wrote about it in 1933 as a key dynamic in the economic cycle, and I've put up that quote. I trust you will see how the privileges accorded to closeout netting and bankruptcy and resolution systems, the ability of counterparties unimpeded by a moratorium to terminate their contracts and dump financial assets into the market, fuels asset value contagion. So the privileges which are supposed to mitigate risk may actually be exacerbating it. Next slide, please. Going to the domino model, the first and overarching point I would ask you to note is that it is impossible to replicate. It is something which is taken at face value, but it has never been replicated in the models run by regulatory authorities in a number of jurisdictions trying to understand the dynamics of financial system crisis. So here are Tobias, Adrian, and Hin Song Shin, highly distinguished regulators and scholars, writing in February 2008, where the global financial crisis had not quite made its severity known, they write, the domino model of contagion has been examined in many simulation studies conducted by several central banks, but the universal conclusion has been that the impact of the domino model of contagion is very small. It is only with implausibly large shocks that the simulations generate any meaningful contagion. Next slide. So here are some of these studies for those of you interested in following up on the literature. I've chosen studies from before and after the financial crisis. Austria, Belgium, Canada, Italy, UK, US. Regulators and scholars have examined how domino contagion might occur in the financial systems of each of those jurisdictions and failed to replicate the toppling of one domino resulting in the collapse of others. The failure of one institution leading to the failure of its counterparties just doesn't happen in these models. So next slide. So that being the overarching point, why might it be that the domino model fails to explain how systemic risk actually crystallizes into systemic crisis? Well, this is my second point. The domino risk view underplays the importance of the intrinsic weakness of the institutions likely to be worst affected by any contagion. Financial sector contagion does not result in the failure of healthy, solvent institutions. This was true even during the Chicago banking panic of 1932, when the only banks to fall were weak prior to and independent of the onset of the panic. This is a point made by Charles Calomares and Joseph Mason in 1997. Further, and in any case, failures resulted from common asset value shocks rather than domino contagion. Individual institutions contributed to systemic risk not through their exposure to each other, but how well they had addressed such exposure as part of their broader approach to risk, and to the extent to which they all had concentrated exposures to the same risk, contagion was likely to be propagated through the system. Next, please. This is the point, this last point about exposure to common risks is my third point. The domino view underestimates the relative importance of pro-cyclical channels and associated vulnerabilities. Point made in 2001 by Borio, Furfine, and Lowe. Again, distinguished regulators and scholars. Increased concentrations amongst parties are a key source of systemic risk and eventually of systemic crisis. But this increased concentration amongst parties benefiting from closeout netting privileges is precisely what is incentivized by those privileges, as Stephen mentioned in his presentation. Next slide, please. So finally, in returning to the failure of very large institutions, you will recall that the simulations carried out by regulatory authorities find that the initial domino to fall, in order for the dominoes to start falling one after the other, the initial failure must be implausibly large. Well, in those scenarios, the domino view ignores the role of asset value contagion. For the dominoes to start falling, the initial failure would have to be very, and as I said, implausibly large. But the larger the distressed borrower, the more likely the amplifying effect of asset disposals as the borrower itself bids for liquidity and as its counterparties attempt to minimize losses. The implication is that the larger the distressed entity, the less appropriate the bankruptcy immunities are in relation to it. Because it's not the domino risk, but asset value deterioration which precipitates a systemic crisis. So this is now a matter of consensus amongst banking regulation scholars and regulators. I provide you with two examples. The first on this page, Frexes and Parigi, my apologies for the pronunciation, make the point that the domino effect simply doesn't explain how crises propagate through the system. Next slide, please. And the same point is made by Allen and co-authors. So whatever we bankruptcy and bank resolution scholars and practitioners might think, banking regulatory specialists have concluded that the domino view is false, it's unsupported. the privileges accorded to closeout netting, which are based on the phantom risk of the toppling of dominoes, in fact, as I've argued, tend to exacerbate asset value contagion. Now, next slide. This is not a new discovery. Professor Kanda mentioned the case of Long-Term Capital Bank. In relation to the aftermath of this bank's failure, the G10, in its report on consolidation in the financial sector in January 2001, highlighted the fact that individually rational action, that is the exercise of closeout netting rights in relation to a distressed financial institution, might be perfectly rational for the counterparty's point of view. But the whole point is that individually rational action may be systemically disastrous. And closeout netting immunities seemed to be contributing rather than mitigating, contributing to systemic risk as a result of this collective action problem. So this is the G10 writing in January 2001. Next slide, please. Exactly the same point. Next slide, please. Thank you. The same point was made by the New York Fed, speaking here through the president of the New York Fed, explaining the Fed's intervention in relation to long-term capital management in 1998. I would commend this to you. Stephen, amongst others, has quoted the statement given to the regulatory authorities by the New York Fed chair in one of his papers. And this is a classic view explaining asset value contagion being operative in the Fed's judgments to intervene, and the point that individually rational action by exercise of closeout netting and termination and collateral disposal rights would have been systemically disastrous. So next slide, please. I should note that while I focused on the domino model and the problems in bankruptcy and resolution of the privileged position of closeout netting, the focus on net rather than gross positions, which is one of the motivating factors behind closeout netting and the privilege it's accorded, has many other costs outside of bankruptcy, as regulators discovered in the wake of the global financial crisis. By way of example, here are two regulators from the Bank of International Settlements writing about the harm done to regulatory transparency by the focus on net rather than gross positions. Next slide. So as I tee up Anna's presentation after mine, I should just bring you up to date. The FSB, the Financial Stability Board, in the wake of the global financial crisis, through the key attributes, now requires that resolution systems provide for a short stay on closeout netting. What is currently envisaged is a stay of no more than 24 to 48 hours, and it's not clear that this would be sufficient to enable resolution authorities to transfer portfolios of financial assets to a sounder institution. So perhaps this time needs reconsideration. But from our point of view, another more relevant problem relates to the common situation in which financial institutions have operations, assets, and counterparties in multiple jurisdictions. And the question arises how the stay imposed in one jurisdiction may be recognized in other jurisdictions where assets and or counterparties may be located. The ISDA protocol provides a contractual response, and I would ask you to think about whether it is an appropriate, let alone optimal response, and whether a possible model law in relation to cross-border financial institutions providing for cross-border recognition of a stay may be a better solution. Next, final slide, please. Thank you very much, and I leave you with this beautiful view of Bowen Island.
So at this point, we turn it over to Professor Anna Kathryn.
Well, so thank you very much, Justice Paquette. Thank you to my co-panelists for being so indulgent of the last minute inspiration, to which I'll turn momentarily, to Helen, to the organizers. It's an enormous privilege of mine to participate in 2 III events in 1 week, which testifies to the reach of this organization, and to learn from so many of the people that have spoken already and that will speak later on in the program. So we have focused so far on kind of the what and the why of the closeout netting mechanism and the relationship between that and bankruptcy and resolution of financial institutions. I will wrap this up by zooming in on a piece of the how, right? So how does this mechanism operate? And then the broader implications of the method that has been chosen so far, as Reese has just flagged. Sorry, next please. So when I saw Professor Kanda's presentation, I was just absolutely delighted because the long-term credit bank incident really completely shaped my interest in this part of the financial universe, and the response in particular and the interaction between public and private actors in this space, in my mind, really does go back to the that incident. So I'm very grateful to the professor for bringing it up. So if you recall, there's a large bank in Japan that is about to fail. And the government and the stakeholders are concerned that the failure of that bank will trigger an enormous wave of closeout of terminations across a range of yen-denominated contracts with enormous macroeconomic consequences. Next, please. And the result, we hope, well, you saw this in Professor Kanda's presentation, right, is the way this is solved, the way this concern is addressed is fortuitously, ISDA issues a statement that clarifies that the procedure that the government was about to use or was using would not in fact be a triggering event under the ISDA contracts, right? And it was fortuitous in rather the same way as, you know, the credit event in the Greek restructuring was fortuitous in 2012. Just there are certain moments in history where ISDA intervenes at just the right moment with just the right kind of technical definitional point that happens to save the day. Next, please. And so I would like to augment Professor Kanda's lessons from this incident and the absolutely fair and correct focus on courts and regulators with another dimension, and that is in a transnational contractual ecosystem like the derivatives markets. Governments may come to depend on private ordering mechanisms. So ISDA is contracts, but ISDA is a lot bigger than contracts. And the press release, right, really functions as a no action letter that you would want from a regulator if the roles were reversed. So in order to create space for traditional public regulatory intervention, like resolution of a financial institution with cross-border contracts and ties, you need input from, you need the private sector to go first and to create that space to make it possible. And private contracts, as a result, become deeply embedded in the regulatory fabric. And there's a sort of a symbiosis between public and private actors in this space, private and public lawmaking in this space. Next, please. So I would like to suggest that we might look at the cross-border bank resolution or cross-border resolution of financial institutions as a sort of a nested political economy, as a set of nested political economy puzzles, right? It entails several different levels of loss allocation. So private. So for example, the contractual provisions for closeout and netting are in effect private actors deciding how to allocate losses in the event of insolvency. There's the public-private loss allocation, so most familiar and intuitive insured deposits, bailouts, but also safe harbors for certain financial contracts, the exemptions from automatic stay, or limits on closeout netting at the national level are a public-private loss allocation device. So if you allow for the assets to run off, right, then there is less left in the institution that is going to be resolved, and therefore there is a higher chance of a call on public resources. And then finally, and this is where I'm actually most fascinated with this, when you get into transnational resolution, there is the public-public loss allocation, right? And you heard about this in Don Bernstein's wonderful keynote, the conversation about ring fencing and subsidiarization, right? The desire of national authorities to ensure that there are assets prepositioned to meet the claims of their nationals or to help resolve their institution are really not just about sort of market loss allocation, but also about ultimately which governments are going to backstop this set of failures. And it's implicitly a public-public conversation. But as Ted Janger said earlier on, since politically we're not allowed to say the word bailout, since politically the premise is there will not be bailouts, everything will be taken care of with private resources, this public-to-public loss allocation conversation is sort of going on behind the scenes. Next, please. So how where is this public-public loss allocation happening, right? And how might you achieve it? So ex ante, you can, if you're credible, you can put explicit limits on insurance. I mean, certainly the Icelandic banking crisis was an interesting case study of that, right? Or you can, as was mentioned earlier, in Iceland, there were no explicit limits, and as a result, all kinds of people who thought they were insured, in fact, found out they weren't insured. And so the Dutch and the British governments had to step in for their nationals who had deposits in Icelandic banks. As you've already heard, there's subsidiarization and prepositioning of loss absorptive capital, of loss absorptive claims. There's also harmonization, right? So a model law or a treaty, something that pre-commits governments to act in a certain way in resolution, is another device for public-public loss allocation. Ex post, we've got bailouts, we've got ring fencing. We also have, you could have a centralized consolidated process or rules about practices dealing with coordination and comity among the authorities. Next, please. I look at the FSB key attributes, and in particular, key attribute 4.2, the one that says that subject to adequate safeguards, entry into resolution should not trigger statutory or contractual set-off rights, as a version of this public-public loss negotiation, right? So it is not just about which private actors suffer the loss, but also which governments backstop it. And having a transnational regime is one way of pre-committing to that. Next, please. I want to recap the contract problem that arises here and why it is that contracts are a relevant unit of analysis, even when we're talking about loss allocation among governments. So suppose you've got a bank that is part of a holding company, you've got the parent on top, the bank is, Bucks R Us, and it's located in a country of Ruritania. It has an agreement with a fund, Pounds for You, in Urbania. Now, the contract between the obligations of the bank to the fund are guaranteed by the holding company. And crucially, the contract between the bank and the fund provides that in the event that something bad happens to the guarantor, the holding company, right, the contract can be closed out, okay? And in the event there's collateral, the fund can keep the collateral, et cetera, et cetera. So everything that we've been talking about earlier. So now we go click, 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 Helen. I'm sorry to do this to you. And I think there's one more click. Thank you. Okay, so in a single point of entry scenario, let's say one of the other subsidiaries of the holding company gets into trouble. We recapitalize the operating subsidiary. It is the parent that goes into resolution, but that can trigger the rights of our fund in the country of Urbania to close out the contract, to terminate the contract with the bank, which can in turn cause trouble for the bank and cause it to fail. Click, click, please. Now, sorry. Well, the point of the previous slide was that the government backstopping the bank that fails is not very happy because now it has a bunch of realized contingent liabilities. The government in Urbania is very happy because its fund and maybe its parent holding company and its friends and cousins are fine and there are no claims on the safety net of Urbania. Now, next, please. So there are several solutions to this problem, at least the problem as it appears from the perspective of Ruritania. You can have a treaty that specifies some sort of ex-ante loss sharing. You can harmonize national laws and regulations so that if, for example, Ruritania requires a stay of closeout and netting rights, right? The fund in the country of Urbania abides by that requirement, even though jurisdictionally the country of Ruritania has no authority, the government of Ruritania has no authority to tell the fund in Urbania what to do and cannot stop it from exercising its contractual rights. Another way of doing it, though, is by contract. And this is where it gets super interesting. Click, please. Thank you. So only certain types of contracts are really amenable to solving this transnational problem, right? This transnational loss allocation problem. Is the contracts happen to be perfectly suited for that? First of all, they are standardized. They start out as a transnational device, New York, London. They cover all of the contracts in this enormous ecosystem, or virtually all of them. And their structure allows for something like a global amendment process, right? So rather than the kinds of atomistic, Joe and Bob meet in a bar and make a contract that we teach to our first year contract students, right? You can amend contracts across the entire market. Right? So an ISDA contract starts with the master agreement, which governs the relationship between the parties, the two counterparties with any modifications in the schedules. It may include collateral provisions in the credit support documentation. And then these parties trade a bunch of different products. For any given transaction, they incorporate a set of definitions for that product, and in the confirmation, the specific details of the deal, right? So if the master agreement, the relationship constitution, if you will, allows for closeout and netting between my bank and my fund, if the bank's holding company is insolvent, right? That affects the entire set of relationships, all the trading between these institutions. How do you fix that? Well, one way to fix it is to put forward a protocol, right, that enacts as an amendment to the master agreement. And these all of these contracts are centrally produced by a trade association, ISDA, right? If ISDA puts forward a protocol, all of the members and non-members now can sign on to, can basically accede to the protocol and thereby modify their relationship constitution, the master agreement, right, to insert this one business day stay or abiding by the laws of the counterparty's jurisdiction governing resolution, so that by signing up, you instantly transform the way in which this market operates. Next, please.
Before we go to the next slide, this is Marianne Paquet. I'm going to interject here just at least to reassure the participants and attendees in terms of time management. Just so participants and attendees are informed, if they look at the schedule, that the closing note speaker has had to cancel at the last minute. So we should be okay to finish the overall presentation at 11:30, but it's 11:26. And I just wish to inform our panelists that our chat room is quite busy. So if we want to address the questions from the participants, maybe we should walk towards the conclusion to that and then turn to the questions of the participants. Thank you, Professor Galpern.
Thank you very much, Justice Paquet, and it is definitely not my intention to eat into the freed up time whatsoever. So I'm actually about to wrap up. So the problem with the contract that I just described is that it's global. It covers the entire market, right? And so if the firm's affiliates are in different jurisdictions, the fact that, say, the United States imposes a one-day stay does not affect what happens, the closeout rights in Japan or in Ethiopia or anywhere else. On the other hand, the positive, the upside of this is that changing the ISDA contracts actually may be easier than harmonizing the laws across all of these different jurisdictions. Click and then, sorry, right? So all you do is you put up a protocol, which is exactly what ISDA did in 2014, 2015, and again in 2016, basically saying that parties that accede to the protocol may not exercise, so agree not to exercise their contractual termination rights and instead defer to the legislation in their counterparty's jurisdiction. Click, please. So Now, contracts are voluntary. How do you get people to accede to the protocol? For regulated institutions, the authorities can just say, do it, right? And the little slide on the right shows you that actually, this is from the latest, about a year ago, FSB resolution report. All the GSIBs, most of the relevant institutions have signed on. Now, exempt asset managers will say, wait a second, I can't voluntarily waive my right to get assets to say seize collateral for the benefit of my shareholders. So what happens then is national regulators go back and say, well, but we're going to require the regulated institutions to require their counterparties by contract to waive those rights. And this is where the 2016 version of the jurisdictional modular protocol comes in, which is tailored to different regulations. The next slide. So what are the implications of all this? This is the end. Public authorities turn to contract and private ordering specifically to solve this transnational problem, right? So this is not a case of domestic delegation of regulatory responsibilities. And this is rather a way for the regulators to piggyback on the distinct form and market structure in this space, which works as a quasi-regulatory infrastructure. Neither side viewed it as first best. But what's interesting is that you can see as time goes on, they sort of become more and more tightly interwoven. And I think that that poses some really interesting political economy questions. And with that, I'm very thankful for being included in here. And I've learned a lot from my co-panelists. Thank you.
Thank you very much, Professor Galpern. With the limited time that we have, maybe, well, I have to choose and pick between the questions that are in our chat room. So I'll go with the first one that was asked, and I will ask, if possible, Dr. Mokal to close the morning with a response to that. Is about closeout netting, whether you think it's a remedy under insolvency law, or whether it should be included in a contract as a way to consolidate debts owned.
Thank you, Justice Paquette. Just very simply in relation to Andrew's question, it seems to me that closeout netting consists of contractual and proprietary remedies. And the question is the extent to which those remedies remain available, notwithstanding that the financial institution has entered insolvency proceedings or resolution proceedings. So it is in that point of intersection between contractual and proprietary remedies on the one hand, and the extent to which they are affected by the onset of the resolution or insolvency regime that are the questions we've addressed lie. With that, I would like to conclude today's proceedings. Dr. Elke Koenig, chair of the EU Single Resolution Board, was to give closing remarks for today's program. As Justice Paquette has mentioned, we learned this morning that she's unable to do so. She will, however, provide written remarks over the next few days, which will be made available to colloquium participants. So I like to thank today's participants first, and most importantly to all of those listening in. Thank you so much. Weekends are precious, and we are grateful that you chose to share yours with us. As to the participants, many thanks to Chief Justice Morawitz and Justices Feldman and Paquette, Don Bernstein, Patrick Ang, Hideki, Kanda, Robert Sanderson, Maziar, Peihani, Ted Janger, Mark Lemix, and Anna Gelpen. Behind the scenes, Helen Toos and Charles Lee, and perhaps most importantly, Professor Janice Serra and collaborators who are putting this program together. I end by commending tomorrow's program to you. It has a superb lineup of speakers and topics. Thank you.